Greetings everyone. Once again, welcome to my YouTube channel. Today I'll be teaching on cyberbullying laws, and I'll be looking particularly at the South African situation. What is the legal framework in South Africa? What are the implications? And I'll also tell you what are the recourse that are available to the one who has been cyberbullied. Cyberbullying is defined as bullying that happens online. That is, somebody bullies you either through text messages or through social media, via YouTube, Twitter, Facebook, etc. Here, it is in a situation where a person seek to harm another, to intimidate them, or even to coerce them. So it is very important that when this happens to you, you take steps, become proactive, and take steps to protect yourself and even to protect others that may be affected by the situation. Now, in South Africa, there are different pieces of laws that have been put in place to address this situation. There are various ways in which a person can seek help once they are confronted with the problem of cyberbullying or once they are cyberbullied. As I said earlier on, there are various laws in place. There are various laws rather in place that caters to address the situation. I want to believe that it's not only in South Africa, but in other parts of the world where there are laws that protect people who are being cyberbullied. Now, in South Africa, I will start with the first law, which is called the Electronic Communication and Transactions Act, number 25 of 2002. This law forbids the use of electronic media to harass or to defame people. So, in other words, once you do that, once you harass people, once you use electronic media or defame people, it's not allowed in South Africa, except for the fact that a person can be sued for defamation of character. So, in terms of this law, there is a violation there. The second piece of legislation in South Africa is called the Films and Publications Act, number 65 of 1996. This particular act controls or prohibits the distribution of harmful content, including content that is harmful to children. So you cannot distribute any content that is harmful. Now, the next piece of legislation is called Protection from Harassment Act, number 17 of 2011. Harassment here is defined. I won't get into the long definition of harassment as contained in this act, but I will just concentrate on the part that I think it's relevant for our discussion. Not that other parts are not relevant, but harassment is said to be directly or indirectly engaging in conduct that you should know or the respondent should know or ought to know that it causes harm. So when you go to social media, whether it's via Facebook or YouTube or any other means, and you engage in that conduct, the law says when you engage in that conduct, you are expected to know, or you should know, that that conduct will cause harm to a person. You are expected to know. And usually, when we discuss things like this, somebody can say, how am I expected to know? The test that will be used here obviously would be what we call an objective test, a reasonable man test. Will a reasonable man in your situation know, or is a reasonable man in that situation expected to know that when you engage in that help, in that act, in that conduct, that it will cause harm to somebody? If you go to YouTube and begin to defame a person, and this person's livelihood is dependent on YouTube, clearly you should know that your conduct would cause harm. And here, harm means mental, it means psychological, it means physical, it even means economic. Because when you go to YouTube, when you go to Facebook and bash on a person every day and you are lying, you are defaming them because there's no truth in what you are saying. It is expected that the intention should be that you want to discredit them, and you in discrediting them, you should know that your conduct will harm their business. There's for harm there, it's economic. You should know, you are expected to know that your conduct is hurting them. Therefore, it's emotionally and psychologically affecting them. Therefore, you cannot say, I did not know. A reasonable man should know. Therefore, you should know that your conduct is harmful in that sense. So, when that happens, when you are able to establish that there is harm in terms of this act, you can obtain a court order to restrain that person from that harassment or from continuing to harm you in that sense. Though this is a civil remedy in the sense that it's a court order which restrains a behavior or a person from continuing with that conduct. If that court order is breached, if the person goes against that court order or violates that court order, though it's a civil remedy, the person can end up being arrested. Now, the final act that I want to concentrate on, which is now the latest development in South Africa regarding cyber law, it's an act called the Cyber Crimes Act number 19 of 2022. We can see that this is a very recent act. In terms of this act, cyberbullying is a crime. This act criminalizes the cyberbullying of an individual. And secondly, this act makes provision that there must be a cybercrime unit within the South African police that will be responsible to investigate, and with the resultant that these cyber crimes will be prosecuted. So in terms of the act, I don't know at the moment because it's still a new act. As you can see, it's a 2022 act and we are just in the beginning of, we are in mid 2023. I don't know whether it's in place already, but in terms of this act, there must be that unit. But however, it doesn't mean that if the unit is not yet in existence, it doesn't mean that you cannot take actions to protect yourself. So there must be that unit whereby the South African police, once you report to them, they will begin to investigate whether indeed there was cyberbullying, whether indeed there is a cybercrime committed, and a person will ultimately be prosecuted for that. The best way to deal with cyberbullying, or as to which act to be implemented, it will depend on the circumstances of each case. I have told you about different acts that are applicable. The Electronic Communications and Transactions Act 25 of 2002. The second one, the Films and Publication Act 65 of 1996. Protection from Harassment Act 17 of 2011, and now finally the Cybercrimes Act 19 of 2022. So these acts can be utilized, can be implemented, and it will depend on the circumstances of each case as to which one will be implemented in your particular situation. I also need to mention that this act, the Cybercrimes Act, does not only focus on the one who is creating, but it also focuses on what is being shared, what is being forwarded. So you may find yourself in a situation whereby you're committing a crime if you share, if you forward, if you distribute information that was created not necessarily by you. So it is very important that we are very careful of what it is that we share, that we forward, and that we distribute. Now, based on my discussion, it is clear that a person can lodge a complaint, number one, with the South African police if you are cyberbullied. Number two, the Films and Publication Board. Number three, the South African Human Rights Commission. Number four, you can approach the courts. For cyberbullying, you can even put it under defamation of character, or you can even take a criminal route of crimen injuria. If in that state you were defamed, you can make it a criminal case, or you can make it a civil case, so you can approach the court. So those are your options that you can utilize in South Africa. And I want to believe that in other jurisdictions as well. I thank you.